Court GC.
But
Next door.
does that happen? You see, I'm being criticized in the press. You can't be, you mustn't sit. You can't be on record in two matters at the same time in the same court.
I think, my lord, it's a party that falls in the recess. There was an arrangement.
No, but you see, you guys, I asked you before the recess started, can we have sessions during the recess? Initially, all of you, except the defense. I think even you didn't.
Yes, I said I was available, yes.
All of Mr. Mnisi said, you know what, I've been reading this record when all of you were resting. I'm tired. I need to rest. Mr. Mshololo said, I'm not available for the whole
Recess.
recess. Mr. Ramusipidi said, this case is messing up my practice. I'm paraphrasing. I'm losing a lot of clients and money, and this case is wasting. And, you know, I've got to be in the office to see what is actually happening because it's messing up my practice. That's what he said. Then Friday, suddenly, all of you, we've had a discussion, all of us, and we have decided we'll sit for the 2 weeks in recess. You know, because my mind is broad. I could have said to you guys, you know what, I already made arrangements to go with my wife on holiday. But because there are certain things which are more important. Then Abundaba wants to talk. One day you'll be a judge. One day. It's a pity when we started, it was still the rule of the Nationalist Party. You would never double book. Never, ever. Because it's in the rule book. Am I right? Yes. You would never do it. The judge will give you a choice. It's either you act for accused number so-and-so, or you act for the other person.
As at the time when the state wanted to re-examine him on certain photos, an objection was raised that there is new evidence, and his evidence then stood down so that the state could first apply for those photos to be admitted, and the state did bring that application, my lord, and the court then ruled that the photos, that the evidence on the photos could be led, and subsequently Warrant Officer Ndlovu and Sergeant Mabaza testified on those photos.
Yeah.
Now the state requests that Brigadier Gininda be recalled so that he can be examined on those photos, my lord.
Is that an application again?
Well, it stood down, my lord. It's not really an application, my lord. We just out of courtesy saying that we request that he should be recalled. We are basically recalling him.
Any objection from the defense?
Not so sure whether the state would still want to proceed with the re-examination of Brigadier Gininda, or the state has already closed its re-examination on Brigadier Gininda on the evidence that was already on court, such that today he is being recalled to come and deal with the new evidence which has been the subject of the litigation for the past 2 weeks, my lord. If that is the case, then on behalf of accused number 1 and 3, we don't have a problem because such evidence has been dealt with very extensively. And as we indicated initially, that will be new evidence, my lord. Thank you.
As the court pleases, madam, I don't have any objection on behalf of Mr. Ntanzi.
Yes, sir. Amaro.
Thank you, my lord. I have no objection on behalf of accused number 4 and 5. Thank you.
Okay. Okay, thanks. You're still under oath.
Thank you, my lord.
Continue with the examination of Brigadier Gininda, the 3 preliminary issues that we want to deal with. The first issue, my lord, the state would have liked to call the dentist who examined accused number 3 as per Exhibit SE. The report has been handed up as Exhibit SE. We have established what the position of the defense is regarding that request. However, we were informed that the defense is going to object to the state calling the dentist. The defense intimated that it is their witness and that we may not call their witness. We informed the defense, my lord, that our position is that accused number 3 was examined by a dentist in public health care at the public health care facility, and we informed them that that is similar to the situation where an accused is examined by a district surgeon during the course of the proceedings for whatever reason, and that district surgeon will then become a state witness. And as a principle, the state has got a first pick whenever there are a number of witnesses available. The state will have the first opportunity to call those witnesses, and if the state doesn't call those witnesses at the end of the state case, they will be made available to the defense. However, my lord, we inform my colleagues that we're not going to make an issue out of that. If the defense doesn't call the dentist, the state will then request that the court should call that witness, the dentist, in terms of section 186. We will then leave the matter at that, my lord. We are not going to pursue it any further. The second preliminary aspect that the state wants to deal with, my lord, it's a proposition that was put by our late colleague, Mr. Mgomezulu, to Colonel Mangena, the ballistic expert, on the 28th of August 2024. We have on various occasions, my lord, intimated that we would like to show the footage that deals with that aspect, as well as the hand up the affidavit of the witness from ENCA who deals with this aspect. We We have conferred, my lord, with our colleagues regarding this aspect, and with a view to seeing if we can perhaps invoke the provisions of Section 213 of the Criminal Procedure Act to hand the footage by consent. However, my colleagues, and subject to confirmation by them, indicated that they are not going to consent to the admission of this affidavit. We therefore have to call this witness. The witness is not here today, my lord. We hope to secure his attendance in due course. We're in discussion with his legal representative. He was subpoenaed to attend court on the 17th of June, 2025. However, he was excused from attending court and being present, as at that time, my lord, we were still in negotiations with the defense, and since we could not reach consensus, we will have to call this witness, my lord. We would like to show the footage today, my lord, and we are going to rely on the provisions of Section 3 of the Hearsay Act. And the reason, my lord, why we want to show the footage at this stage is we would like Brigadier Gininda to comment on the on the footage. And may I just briefly refer then to Section 3 of the Law of Evidence Amendment Act 45 of 1988, which provides as follows. Section 3, hearsay evidence, says, subject to the provisions of any other law, hearsay evidence shall not be admitted as evidence at criminal proceedings or civil proceedings unless, and we are going to refer to subsection 3, which is relevant here. It says, hearsay evidence may be provisionally admitted in terms of subsection 1B. And section 1B reads that the person upon whose credibility the probative value of such evidence depends himself testifies at such proceedings. Now, subsection 3 reads that hearsay evidence may be provisionally admitted in terms of section 1B if the court is informed that the person upon whose credibility the probative value of such evidence depends himself testifies in such proceedings, provided that if such person does not later testify in such proceedings, the hearsay evidence shall be left out of account unless the hearsay evidence is admitted in terms of paragraph A. And paragraph A says that each party against whom the evidence is to be adduced agrees to the admission thereof as evidence at such proceedings. Or subsection 1. Subsection 1 basically, my lord, gives the discretion to the court to admit hearsay evidence after having had regard to the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, the probative value of the evidence, the reason why evidence is not given by the person upon whose credibility the probative value of such evidence depends, and any prejudice to a party which the admission of such evidence might entail, and lastly, any other factor which should, in the opinion of the court, be taken into account. Now, subsection 4 defines hearsay evidence as follows. Hearsay evidence means evidence, whether oral or in writing, the probative value of which depends upon the credibility of any other person other than the person giving such evidence. Now, my Lord, as indicated, would like to show the footage which deals with the proposition that was put by Mr. Mgumezulu. And we see that in the proceedings of the 28th of August, 2024. And my Lord, I'm just going to read out the proposition just merely to show relevance, and not for any other purpose, my Lord. During the proceedings of the 28th of August, 2024, page 11, line 19, Mr. Mgumezulu. All right, let me put this version to you. According to those witnesses that I do not want to disclose at this stage, 3 shots were fired. 1 shot is the one that caused injury to Zandi on her leg. The other shot is the one that Longwe Twala shot himself on the leg while they were struggling for the gun. The third one is the one that shot Senzo Meyiwa, but I'm not mentioning them according to the sequence, how they happened. I mean, all these 3 shots, they caused injury to Zandi. The one was stuck in the ankle of Longwe Twala, and the other one is the one that shot Senzo dead. Then in line 10 on page 12, Mr. Mgumezulu, Longwe, after that incident, that wound became septic, and he went to a doctor, the late Dr. Mbatsani, who referred Longwe Twala to Dr. Mudise in Ren Hospital, where a bullet was taken from Longwe's foot. Now, my Lord, the purpose of this footage is to deal with this proposition. I will then, my Lord, maybe just allow my colleagues to make submissions if they have any submissions to make in the in this regard.
Yes, Mnisi?
As it pleases the court, my Lord, the first aspect that is stayed intimated that it is that it would wish to call the dentist who examined Mr. Sibia, Mr. Mnube, and whose report is already before court, and the state is basing that on the argument that in every circumstances the state has a first pick on witnesses. That is a gross misrepresentation of facts, my Lord. This witness, for starters, Dr. Ali is nowhere seen in the list of state witnesses. The state can only have a pick of witnesses when they specifically state the name of that witness in their list of state witnesses in terms of Section 144 of the Criminal Procedure Act. Dr. Ali, it's none of those witnesses. The state argues that by virtue of the fact that Dr. Ali works for the state, he then automatically becomes their witness. It also does not work out like that, my lords. If the state wanted to use Dr. Ali as their witness, the state should have made it a point that Dr. Ali does what the defense requested him to do, which is to assess Mr. Mnube, and then the state comes and includes him, as one of its witnesses in the list of state witnesses. The state cannot simply say because he works for the state, then he therefore automatically becomes their witness. It does not work out like that, my lord. For the fact that this process was initiated by the defense, and the defense approached Dr. Ali, who is working for the state, that simply means that Dr. Ali has been requested by the defense to come and assist the court. Who made that request is the defense. Therefore, whose witness is that? Is the witness's defense. It's very simple, my lord. There are so many witnesses that we would have loved to consult, which witnesses are in that the defense would have loved to consult, whose names are in the list of state witnesses. And we are quite certain that some of those witnesses would provide some evidence that is favorable to the defense. That's an open secret. But for now, we'll not be able to do that because those witnesses are in the list of, their names are in the list of state witnesses. We can't even go near them. Exactly that is what the state wants to do. It's like the defense has got its own list of witnesses and say, this is our list of witnesses. And then the defense comes and say, no, but that one is working for the state. He can't be your witness because he's working for it. It does not work out like that. He's our witness. I think the proposal by the defense, by the state, that in an event that we choose not to call Dr. Ali to come and testify in the defense case because it's our witness, then the state is going to make an application in terms of 186 to request the court, in the interest of justice, to have Dr. Ali called. But the state cannot call him. How will they then be in a position to interview our own witness? That will be a very gross irregularity, my lord. If that is what the state wants to do, state must stand up and say it also allows us the opportunity to interview the witnesses at this very same moment that they will not be utilizing later on, even before they close their state's case. I know the state will not do that because that is unprocedural. They are not yet our witnesses. They are still part of the state's witnesses. They have not been disclosed to us. The state does not even say to us, will you be calling Dr. Ali? Are you amenable to disclose Dr. Ali to us? The state simply says that, no, I want to call that witness because he's working for the state, and simply because he's working for the state, then we've got a first preference. It does not work out like that is a very gross, that will be a very gross irregularity of a procedure, my lord. Thank you. I think the last aspect, the 186, it covers everything, my lords. That's just my submission in the first instance, my lords. Now, with regard to the proposition that, I'm not so sure if thank you, my lord. Now, with regard to the proposition that was put by Mr. Mngomezulu on some of the witness here, it is indeed so, my lords. that upon being approached by the state, we recorded our vehement objection to the procedure that the state wanted to adopt or to employ. And basically the state, my lord, does not give the court the background of what is happening here. Remember Mr. Mngomezulu said, as per the quotation that has been read on record today, Longwe was one of the people who apparently got injured in the house. Now the state wants to refute that allegation. Now the state says, we want to refute that allegation by showing a video that shows Longwe that the following day, that's the information that we got from the state, that the following day, Longwe was seen walking very straight, he was not limping, and which is an indication that he could not have been injured on the 26th, because on the 27th, he was seen, he's being seen on the video, he's walking very straight, he's not limping. But that on its own has got its own challenges, my lord. And the state says, no, we got a clip of a video from ANC, ENCA, yes, I'm sorry, from ENCA. We got a clip of a video that will demonstrate that Longwe immediately on the 27th he was seen walking. But that has got various challenges, my lord. And those challenges are as follows. Just before I get to those challenges. The state says, no, we want to rely on exceptions to the hearsay rule. We want to lead this evidence on a provisional basis and allow the brigadier here to opine on the content of the video itself. And the state is saying it will be in the interest of justice that such videos should be shown and therefore allow Brigadier Kininda to opine. The state does not even say that after the acceptance or the admission of this hearsay evidence on a provisional basis, what would then happen with regard to it being accepted as part of the record? Finally, it does not say to the court what is going to happen to that, but now these are the challenges that I mentioned earlier on, my lord. Number one, the statement, the 212 statement or the 213 statement that the state says was penned by, that the state said it received, and it is through that statement that it wants to introduce this video. It is a statement by a certain gentleman known as Mr. Bailey. We got that statement. Now, Mr. Bailey simply says to the state, on paragraph 5 of his affidavit, this is what he says, and he says it emphatically. He says, on paragraph 5, I have no personal knowledge relating to the presence of Mr. Twala at the home of Ms. Kumalo on the 27th of October 2014, as I was not present at a residence. In fact, at the time I was not working in South Africa. I was in fact working in China. To repeat, I have no personal knowledge regarding the events, people or places depicted in the footage that is requested. So how does then Mr. Bailey assist the court here? Because he simply addresses the question that we are taking up as an issue with the state. Number one, how are we going to know as to when that video was taken? Who will come and tell this court that, no, this video was actually taken on such and such and such a day, on the 27th of October 2014? Who will come and say that? Who took that video? Under what circumstances? Why was that video actually taken? Those are all the things that the state is hiding from the court. But more importantly, my lord, more importantly, the state says that the probative value of this video, which is hearsay, lies on Mr. Bailey. Mr. Bailey says, no, it can't lie on me because I was not present at the residence. I was working in China. And it says to repeat, I have no personal knowledge regarding the events, the people or places that are depicted in the footage. How can it then be argued that the probative value of this video that Mr. Bailey distances himself from can lie on Mr. Bailey? It is worse with Brigadier Kininda. It is even worse with Brigadier Kininda. He will be called upon to give evidence or to give an opinion on something which the court will, something that the court will not even know. Where does this thing come from? For starters, we don't even know where was this video taken, whether it was taken at the hostel, whether it was taken at the tavern, or whether it was, because we've seen the video. It's a 5-second clip of a video. Or 34 seconds, yes. It's a 34-second clip video. Where it was taken, we don't know. For what purpose, we don't know. But my lord, this is what should concern the court very attentively. Mr. Longwe, he's one of the state witnesses that is mentioned in the indictment. Let me repeat again. Mr. Longwe is one of the state witnesses who is mentioned in the list of state witnesses in terms of Section 144 of the Criminal Procedure Act. The state, by simply including him in the list of state witnesses, gave out an impression that if circumstances were to arise that Mr. Longwe should come testify, we'll definitely call him. Therefore, you as a defense, stay away from him, because as of now, he's our witness. Now, the question that begs this court is, and that should actually trouble the court, my lord, very gravely so. Mentioning Longwe in the list of state witnesses, that is the person on whose probative value on what is happening on that video lies. It is only Longwe who can come and tell this court, yeah, no. Actually, the state does not even have to call that video. It does not even have to play that video. It simply has got to say to Longwe, Mr. Mgomezulu made these allegations to you that as and when this incident happened on the 26th of October 2014, you also got injured on your feet. Those are the allegations that Mr. Mgomezulu put to one of the witnesses. Do you agree with those allegations or not? And then he comes and tells this guy, I know, I never got injured today. Mr. Mgomezulu probably, I don't know, got that version from. That's the best evidence rule. Why is the state afraid? Or avoiding, really not afraid? Why is the state avoiding to call Mr. Longwe, my lord? Longwe Twala. Why is the state afraid? I have tried to come up with speculation and answers to which ingenuity may suggest. I can only think, my lord, and I'll be forgiven for thinking that the state is afraid that Mr. Longo comes here. He says, no, I never got injured on that day. But beyond that, let me tell you how this incident happened. Actually, the firearm that was used on that day was not a 9mm, it was a revolver.
This court
That's
can-
just a speculation.
This court can't listen to speculation.
Yes, thank you, my lord. But the gist of the question is, why is the state avoiding to call Longwe? The state does not say Longwe is no longer available. The state does not say that Longwe is untraceable. He is still there. That is the person on whose credibility and the probative value of what is depicted on that video lies, my lord. I would therefore strongly object in the strongest terms that that video should be played here and for Brigadier Kininda to come and opine on that video. What will he be saying? And in fact, the court has just indicated that it does not want to listen to speculation. All that Brigadier Kininda is going to say will be speculation, my lord. Thank you.
Yes, sir.
Sorry, my lord. May I just summarize
Now
everything?
let the defense finish and then you
As a
summarize for all three.
The court, please, my lord.
Okay.
As the court pleases, my lord, two submissions really. The first one pertains to the applicability of Section 3, subsection 3 of the Hearsay Evidence Act 45 of 1988. And I say, my lord, with the greatest respect to Advocate Baloyi, that does not find applicability, my lord. My lord, we will have learned from the Baleka cases, the Singh, the Ramgobin, that video evidence is real evidence, and generally it is not considered hearsay. Hearsay will only arise, my lord, if in the video the persons depicted are making statements, and those persons are not available to come and confirm the statements that they made in that video. Otherwise, it is real evidence. There's no hearsay act applicable here, and I'll tell the court why. Mr. Mnisi has introduced, by way of submission, what we have seen in that video. That video is a 34-second video, my lord. It does not show any person uttering anything, or at least it is not audible what the utterances are being made. For that reason, my lord, I'll say the Hearsay Act does not assist the state in trying to bring Longwe's evidence via the back door, via Mr. Bailey, who says, in fact, what he obtained was not a video of 27 October 2014, but it's a broadcast of 10 October 2024. That was a rebroadcast, and it contains the subject matter of the subpoena that was served upon him by the state. He does not say it contains this footage. He says the subject matter of the subpoena. I don't know what the subject matter is. The state will clarify that for the court. I'm not privy to the subpoena that was served. It was never disclosed to us, my lord, and I don't think we also belong in the serving of that subpoena, my lord. Now, with video footage, my lord, it needs to be authenticated that it represents accurately what it purports to be depicting. Now, if only that it shows its action and not words, no oral utterances, I'm still standing, my lord, that without utterances, the Hearsay Act does not apply, my lord. Now, the second aspect, my lord, is, and just to concretize this point, is the one that Mr. Mnisi touches on. Mr. Longwe Twala is alive, my lord. In fact, my lord, if I go back in 2023, before Mr. Host testified, we received an email from Advocate Baloyi informing us that we must prepare that because they were going to call, amongst others, that Monday, Longwetwala, Jack Buthelezi, and Mr. House, Colonel House. And about 10 was made later to say, no, prepare only for Jack Buthelezi and Mr. House, my lord. I understand, my lord. I've been practicing for 100 years. The state is dominus litis. Why they decided at the last minute to withdraw Mr. Longwe to come and testify is their own prerogative, my lord. But the point that I'm making, he's still alive and kicking. And but what we have read in the media, my lord, he's sobering up from whatever is afflicting him. So he's a compellable witness to be called and testify on this aspect, whether or not he was shot at and injured on the 26th of October 2014, my lord. My lord asked me the other day whether I read Canadian law, and there's an important term that was mentioned there by one of the judges, and so Pinka was also in that judgment, which says a witness like Mr. Gininda for this purpose is not going to assist the court and ourselves, my lord, to know that the person depicted on that video is Longwetwala. I don't know Longwetwala. The court does not know Longwetwala. My colleagues, I believe, they don't know Longwetwala. We are going to listen to the say-so of Mr. Gininda that this is Longwetwala. That, my lord, in Canada has been held to be a supererogatory and unnecessary evidence by Sopinka. So, Advocate Baloyi is inviting this court to listen to the most superfluous evidence that will come from Brigadier Gininda, with the utmost respect. Brigadier Gininda is not going to assist the court in that respect, my lord. So I submit, my lord, and vehemently so as well, that this video should not be played in court until it's authenticated by the relevant people under oath, my lord. Not through the Hearsay Act that is not applicable, not through the superfluous evidence of a lay opinion of Mr. Gininda, my lord. Brigadier Gininda, I'm sorry, my lord. As the court pleases, those are my submissions, my lord.
Yes, Mr. Kamamalo.
Thank you, my lord. The first issue that I want to address is the issue of the witness. Dr. Ali.
Yeah.
My lord, the stage at which the state can boldly say that that witness is theirs has gone past because of the propositions that were put by my learned colleague, Advocate Mnisi, to Sergeant Mabasa under cross-examination. There's versions, there's propositions, there's the contents of the report that was put to Sergeant Mabasa by my colleague during cross-examination. So the state cannot say now that that witness can be called by them. That is the state, because it will be ran parallel. The defense is calling the witness. On the same breath, the state wants to call that witness to testify on the very same issues that the defense has raised. So that is totally unacceptable. On the issue of the video, firstly, I wish to mention in respect of what happened after that video was taken, where it was stored, up to the stage when it was played by or handed to the state for them to use it in this trial. We don't have even the statement of a person who took that video. We don't know when it was taken and the time when it was taken. Safe to say that we were told that that video was taken on the 27th of October, 2014. That is the following day. The person who is depicted on the video, I'm instructed by my client that he doesn't know that person. As to why that person is not called here in court to come and testify, we don't know. It is my submission, my lord, that the applicability of the Hearsay Act is not relevant in this application or the submission by the state because we don't have anything. We don't have affidavit in support of the video. As I've indicated, my lord, we don't have chain statements of the person who took the video as to where it was stored and the person who is depicted on the video to say that he is indeed the person who is there. We don't have such. So it cannot be said that the applicability of the Hearsay Act is relevant in this aspect. And again, my lord, in this matter, I can say it without any reservation because I can see that time is against us. We seem to be going in circles, my lord. The assertions by Mr. Mgomezulu were raised in this court on the 28th of August, 2024, some 10 months, as to why this was not pursued after Mr. Mgomezulu, may his soul rest in peace, was not followed. The issue of the video was not followed. We don't know, because one would have assumed that after such assertions were made by Mr. Mgomezulu, then the state was going to pursue the issue of the video to lead that evidence. But now it wants to lead that evidence through Brigadier Kininda, of which when the matter was adjourned on Monday to today, we had expected that Brigadier Kininda was going to be re-examined on the aspect of the application that was granted by this court, having been made on the 17th of June, 2025. So I really must say, my lord, that we seem not to be making any progress in this matter. Thank you.
Yeah, can you interpret?
I think it's crucial to distinguish between two concepts. The first one is relevance, and the second one is the weight to be attached to the evidence. And I think what my colleagues have put emphasis on is the weight to be attached to the evidence. But the first hurdle, my lord, is relevance. Evidence can only be admitted if it's relevant. And at this point in time, the question is whether is the evidence relevant? And we submit, my lord, that it is relevant. The court has previously referred to Section 210 of the Criminal Procedure Act, which reads that no evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point of fact in issue in criminal proceedings. Now, we have argued in the past, my lord, that we have facts that are in issue, and the Latin term that is sometimes used is the facta probandum. And you have facta probantia. You know, those are the facts that you use to prove the facts that are in dispute. Now, you can only lead a fact to prove a fact that is in dispute if that fact is relevant. And we submit, my lord, that the evidence is relevant. And I want to deal with the submission of Mr. Ramsipili that this is Section 3 of the Hearsay Evidence Act is not applicable. And I think that aspect was also touched upon by Mr. Numalo. My lord, the fact is this, you can have real evidence, which is the footage itself, but if you want to prove the contents of that footage, that becomes documentary evidence. And I think that is where my learned friends, with the greatest of respect, miss the point. And once you want to prove the contents of a real exhibit, as I indicated, that becomes documentary evidence. And you can only prove documentary evidence through three means: by calling the author. Firstly, the documentary evidence must be relevant. And secondly, you must call the author to prove the contents thereof. And thirdly, you must prove the authenticity of that documentary evidence. And that is precisely, my lord, what the state seeks to do. The court will remember in the olden days when there were illegal gatherings were prohibited. Tape recording is made of the proceedings. Someone would come, a policeman will always come and say, the video will be played, and they'll come and say, so-and-so on that video, it's accused so-and-so, and the person on the video is accused so-and-so, you know. That is when you prove the contents of real evidence. Mr. Numalo questioned us why the state took long to present the evidence. We have, on the previous occasion, my lord, indicated that there's a certain procedure that you must follow if you want to tender evidence from media houses. We indicated, my lord, that there's an agreement between South African National Editors Forum and the law enforcement agencies that you have to follow a certain process if you issue a subpoena. And we did indicate in this court, my lord, that we started this process as far back as December 2024 in securing the subpoena, because the subpoena must be authorized by the National Director of Public Prosecutions, and thereafter the matter then goes to a local magistrate in Boksburg, and a subpoena is then issued. That is the route that we followed in the current instance. As far as the submissions of Advocate Nisi are concerned, I think we did indicate, my lord, that we're not really pursuing the issue of the dentist any further. I thought the matter will then be left at that. But he also, with the greatest respect, my lord, submitted that there was also this obfuscation between relevance and the weight to be attached to the evidence. And I think, with the greatest of respect, Advocate Nisi was arguing the weight that should be attached to the evidence. He mentioned that Mr. Bailey states in the affidavit that he bears no knowledge of the events. He was in China, but it's not about that, my lord. It's about the authenticity and reliability of the footage, and that's where Mr. Bailey comes in.
Sorry, is he the person in charge?
He's the news editor.
The news editor.
Yeah, he's the news editor at ENCA, under whose custody the material is archived. Mm-hmm. And again, to deal with the issue that was raised by Mr. Ramsipel as well as Advocate Nisi about the fact that this evidence that can be of no assistance to the court, except if Mr. Longotwala is called. Well, two submissions in this regard. Firstly, a matter is decided on direct evidence or also on circumstantial evidence. And there's nothing that debars Brigadier Gininda if he can identify a person on a video to state as to who that person is. We've just been through that exercise, my lord, with the photos, where the witness would look at the photo and state what they can observe on the photos. That's That's perfectly permissible, my lord. But as to the question as to why the state is not calling Mr. Longetwala, my lord, the state doesn't have to call every witness whose name appears on the on the list. If the
Mr. Ramosepedi, you're saying it's not in the interest of justice for this court to view the clip. It's not in the interest of justice. Or actually you're saying the Evidence Act doesn't allow that.
My lord, I'm interpreting.
Let's start here. Does
Yes.
the Evidence Act allow such a procedure?
My submission is that it does not, my lord.
It does not.
It does not.
Which section is that?
Section 3,
Read it.
subsection 3.
Yeah, read it.
Your CPA. You must put on your specs if the writing is too small. Where is it? Yeah, section 3, subsection 2, 3.
Are you fine with your
Yeah, my eyes-
provisionally allow that evidence. And subsequently, if that witness doesn't turn up,
Then it's
then
not
the
considered-
court can revisit.
Yes.
Yeah, so where's the prejudice for your clients?
My lord, the two riders are, the court is quite correct. The one rider is the interest of justice. The other rider is the probative value. What probative value does
I don't know.
this evidence?
The state will have to argue that. I don't know.
That's the other thing, my lord, that you are not told the probative value. Hence, I, in my submission, said it doesn't help the state.
But I take it the
To
state,
argue hearsay
the
evidence.
state won't just call. This judge puts it like this.
I'm sorry, my lord.
I said that the judge putting it, you don't call a motley of evidence for the judge to see what to do with it. If the state calls any evidence,
Yes.
it must be for a specific reason. So when Mr. Baloyi or Dr. Sibanda call evidence before this court, it must be typified by the fact that it's in pursuance of the case we are dealing with.
I understand the court, but my lord, why will that then be inadmissible evidence?
Which evidence is inadmissible now?
If the court says they are bringing each and every evidence to court for a particular reason, there's some of the evidence that's been ruled inadmissible, but they brought it anyway.
Yeah, sometimes you do rule it out.
Yes. But my lord, as well, before I finish on this point, Advocate Baloyi addressed the court on relevance, and it's quite correct. But if we go to, the cases on relevance, Kurtz, Zuma, Torpedo on dog attacks and dog tracking, whatever, we are not saying that the evidence is not relevant,
What are you saying then?
my lord. There's a distinction.
Because the state is basically saying, wait, that evidence is relevant. And now you are telling me we are not saying that evidence is not relevant.
My lord, it's how evidence is procured and brought before court.
He says he's got a subpoena which he has served in terms of an agreement apparently which the South African police have with the news agencies.
Yes.
So that's how he says Bailey comes into the picture to authenticate.
Because the other misnomer that I had, my lord, from the response by my learned colleague was that this is documentary evidence. But if we read the two Balekas, where Van Dijkhoff clearly says we mustn't confuse video footage evidence with documentary evidence, because on the latter, which is the video footage evidence, the best evidence rule does not even come, because you can introduce a copy if, for instance, the original has been lost, as long as also it can be authenticated as to originality. Authenticity goes only to weight, my lord. So we mustn't, according to the Balekas, that's what it says. As the court persists, my lord, those are my submissions.
Yeah, having listened to, if the state argues that the evidence which it wants to lead now is relevant, then this court cannot deny the state to lead that evidence. Because the defense, in any event, if it feels it is prejudiced, they can cross-examine on the basis of the evidence being inadmissible. So consequently, the application is granted.
As the court persists.
As the court persists, my lord.
besho khona njalo ke isinqumo se
The cap and wearing jeans. Are you able to recognize or identify the person?
That is correct, my lord. It is Mr. Longo Twala.
bathi khona ke umuntu otshangakalayo ke kule video logqoke ke cap ke na ke futhi nesikhindi sejini ke na ke bathi ufakazi ngabe uyakhona yini ukubona umuntu loyo nathi yebo kunjalo ke uyakhona ukuthi ambone athi ulongwe Twala.
Can you tell the court how you know Mr. Longo Twala?
Bacela ukuthi tshele kusenkantolo ukuthi ngabe umazi kanjani ke umnumzana ulongwe Twala.
I've met him, my lord, during the course of the investigation, and the last time it was when he was consulting with the state advocate at the DPP's office here in Pretoria.
Athi wahlangana ke ngesikhathi lesi kade besenza kusesha kwecala ke labo ke lapho ke futhi obe wahlangana ogcina ehlangana naye wahlangana naye ngaphakathi komofisi abashushisi ke lapho ke la ePitoli.
The state is going to request that video footage be handed up as an exhibit, the Exhibit 8.
Or to be handed up through the ages of Bailey. Am I correct, sir?
Yes, indeed, my lord.
That's how I understand evidence.
Yes.
Bailey is going to say, I am a coach of Kaizer Chiefs. I was there when Rata Mokhatling lost his eye. That's all he's going to say.
Yes. Indeed,
Yeah.
my lord. Depicted there, are you able to recognize the lady?
That is correct, my lord. That is Miss Zandi Kumalo.
Bathi khona ke video footage
But yes, it is a vehicle it's a BMW X6 that was belonging to the deceased. It's his vehicle that he had then.
In the movement or the gait of the person that you've identified as Mr. Longo Twala?
Well, yes, my lord. He seems to be walking fine, contrary to what was put to me, that he may, or that where I was told that he was limping and there was a shooting and on the ankle. So that's what I see on the footage. It's not an indication of someone who sustained an injury, particularly a bullet wound injury on the ankle. I don't think someone would walk like that, in my view, my lord.
bathi uyakhona
Are you able to identify the house where the footage is depicted?
Indeed, yes. That is the house, the 1335 Kutwano Street, the crime scene, my lord. That is the house where the deceased was shot, and that is the house that belongs to the Kumalos in Fostoras.
bathi mina nomuzi okhona ke lapho
Yes, I am aware, my lord, yes.
manje ke kusafaka lapho kuya khona iqala lezi